computer. Go. I'm going to share the screen. There we go. Can someone please confirm that they can see my screen?
Yep.
Perfect. All right. So, is it, by the way, is it a full screen on yours? Like what you see, is it a full screen?
No.
Oh. Does it help if I actually increase the size of mine like this? Did you see a difference or not?
A little difference, but it's still legible.
Okay. Still legible. Okay, well, legible is good.
That's legible too. Yep.
All right, awesome. So guys, we are going to talk about property damage and what happens when it's discovered before and after closing. You know, some of our talks are pretty in-depth, detailed, and bring up fascinating sort of revelations. And, you know, taxation may be very detailed and highly complex. Defects are not necessarily that. In fact, defects and what to do about them are pretty easy to understand. Sorry, I'm just going to make sure that we have everyone muted if you guys don't mind. We do have quite a bit of background noise, so just 1 second, please. So defects themselves are actually not that complex, but still knowing what to do about them and knowing the tools in a lawyer's arsenal are really what we're going to discuss today, and what a lawyer does when they discover defects. Of course, defects that we're talking about are not just defects in a house that exist. They're defects that exist after you sign your agreement of purchase and sale, either before you close your property or after you close your property. So without further ado, this is kind of what our agenda looks like today. Look how organized I am today. I even have an agenda. So we're going to start with the very basics. And the basics really should be obvious to all. But you know what? When I think back to it, when I started in real estate, I don't know that it was. And the basics don't necessarily only take place in real estate. This is a basic concept in contracts that the buyer has to beware. That is to say, if you're not buying something new, then there's probably defects. Heck, I'm 44 years old. My body was much better at the age of 20. If someone was capable of buying me today, they would find a body that simply isn't in the state of a 20-year-old, nor is there any reasonable expectation that I would be in the state of a 20-year-old. And that's a really bad example of what it is that people purchase, obviously. But if we were to turn our attention to a new car, to a used car, if you purchased a property, if you purchased a car and, you know, after 1,000 kilometers, let's say it has 125,000 kilometers on it, and after 1,000 kilometers it broke down, you wouldn't be able to hold it to the standard of a new car. You would basically, the seller would say, what do you want from me? It was a car with 125,000 kilometers on it. Buyer beware. And so it is in resale real estate. Resale real estate is you aren't buying new construction. You don't have a right to something that is brand new. You have a right to what it is that it appears to be, which is a resale property, warts and all. And the default position of the courts is caveat emptor. And this matters, and the reason I'm starting today's discussion with the basic language of what happens in these transactions is because upon the discovery of a defect, it will be the case almost every time that the seller says, well, it's caveat emptor, it's buyer beware. What do you want from me? And the question that we are asking today, the real thing we're going to address today is, all right, so I'm acting for a buyer who has discovered a defect. I know that the seller is going to say, your problem, caveat emptor, how do I get around it? How do I put the onus back on the seller and say, yeah, caveat emptor, but. And in order to do that, there are several tools that are in our arsenal. The first tools, of course, are the common law. Now, I just want to back up again. I know that we have quite a few people online, and I'm just going to quickly talk very plainly, because I haven't talked about this in a while, as to what the common law is. The common law is a body of law that, even if not written down, surrounds all of us. I've used this example before on the forum, but I see Sandra's prominent cartoon pic actually presently on my screen, so I'm going to pick on her. If Sandra were to come up one day and punch me in the nose. Why is she not allowed to do that? Now, you might say, well, that's illegal. And indeed it is. There is a criminal charge called battery that precludes Sandra from punching me in the nose. But that criminal charge does nothing for me. I've had to spend 3 weeks off work. I've had to go through hospital visits. And all that's happened is the criminal charge has been levied against Sandra, which means that what she's done is such an offense to Her Majesty the Queen that she's ended up in jail. Okay, fine. But what recourse do I have against Sandra? Well, believe it or not, outside of the criminal law, there's no law that has ever been passed by the Ontario legislature that basically says, hey, Sandra can't punch Mark in the nose. And yet, Mark can still sue Sandra because there is a wrong in common law called battery. Battery says, or what happened is, over the course of hundreds and hundreds and hundreds of years, many Sandras have punched many Marks in the nose. And over the course of hundreds and hundreds and hundreds of years of going before magistrates and judges and lords and everyone else, judges have said, you know what? Every time a Sandra punches a Mark in the nose, we are going to call that a wrong. We're going to call that a tort. And that actionable wrong will give rise to damages. And so even though it wasn't written down anywhere in our legislature, it still became the law. And there are any number of torts in this world, like nuisance, like battery, like trespass, and I can go into it. Some of them have been codified by statute, some of them haven't. But there's a range of common law torts that perhaps can get us around caveat emptor. Let's explore some of them. The first one that I want to talk about is concealment. Now, it is the fact that if someone conceals a defect, it is, in fact, a voidable action for a contract. So if, as an example, there was, so I once acted as a realtor, actually, for a client who was buying a house. And that realtor saw this house. It was resale. It was like 25 years old. And went into the basement, checked everything out. Came back after everything had been removed. And it turns out that there was a giant hole in the basement that was covered previously by a carpet and a desk that sat over top of that carpet. Clearly, the sellers well knew about the hole in the basement. Clearly, it was the case that they were concealing it from the purchasers. They never mentioned anything. They put the carpet over and then the desk. And in that instance, it is the case that there would have been very clearly a claim as against the sellers, even though they could say caveat emptor, buyer beware. The buyers could say, you know what, you were concealing this, and under common law principles, you have acted improperly. Harking back to our days in England, you have acted improperly, and an action could be brought against them. Now, what would the action be in that case? We'll talk about that as part of this lecture or session. But concealment is a valid thing to claim. In addition, you can claim innocent, negligent, or fraudulent misrepresentation. We talked about these terms during a previous session on basic contract law, where we went over, everything you need to know about contract law. But you can have innocent, negligent, or fraudulent misrepresentation that takes place either in contract or in tort, in the words that you have chosen to speak to someone else. So misrepresentation is a statement of fact. I'm going to go over this again. I apologize if this particular point is a reiteration of what we went over during our contract session, but it's brief, so just bear with me. There are three flavors of misstatements of fact. So what's the difference between fact and opinion? I think this is a really nice pool. That's a statement of opinion, right? You think it. In fact, anything that starts with I think, there's really no way to make it into a statement of fact. It's just an opinion. Whereas this pool will last you 10 more years before you need to put a cent in. That's a statement of fact, right? It's giving you a very definitive thing that you can rely on. If you make a statement of fact that is incorrect, it could take one of three flavors: innocent, negligent, or fraudulent. Innocent, and this is the example that I used in the last session. There was a case that I was dealing with as a lawyer, and that case was someone who sold their home. And they sold their home to a new purchaser who cared very much about getting their kids into a requisite school district. And they said, "Is this home in that school district?" And the seller responded, "Yes, it is. I sent my kids to that school," which was a true statement of fact. At least the second part was. She did send her kids to that school. Unbeknownst to the seller, the school boards had reorganized, and her house had now been placed into a different school district. She made an innocent misstatement of fact. Still a misrepresentation, but it was innocent. She had every reason to suspect that it was in the school district. She had sent her kids there for many years. Valid reason. But gave rise to damages. In fact, it was a huge kerfluffle when we had to deal with this. That's very different than a negligent statement, which would have taken place had someone turned around and said, "Oh, yeah, you can absolutely send your kids to that school," without having a clue as to whether or not you could do it. I mean, would a reasonable person have done that? They would not. And that's even more different than a fraudulent misrepresentation. And a fraudulent misrepresentation is knowing that someone couldn't send their kids to that school and still saying, "Yes, you can." And if, in fact, someone makes an innocent, negligent, or fraudulent misrepresentation that the purchaser relies on in making a decision, well, they can get into a lot of trouble. And it is possible that that can be put up as a defense against caveat emptor. In other words, the seller would say, "Sorry, you take the property as you find it." And the purchaser says, "Aha, but I did my diligence and you induced me to enter into this contract through your innocent, your negligent, or your fraudulent misrepresentation, which is an actionable wrong for which I am seeking damages." Again, we'll talk about what the damages are shortly. We're just presently talking about the actionable wrong. And it's worthwhile me pausing for a second and saying what I say so many times in these lectures, which is there are two components to any legal case. First, you have to prove you're wrong. And after you've proven you're wrong, then you ask for judicial relief in the form of damages, rescission of contract, God knows what, we'll talk about it. All I'm talking about right now is if you discover damages pre or post this agreement of purchase and sale being signed, what are your legal rights in form of proving a wrong before the court, which will then give us the remedies we need in order to correct the wrong, which we will talk about. So we've talked about two common law concepts: concealment and misrepresentation. Let's talk about some more. Let's talk about the right to receive what you've contracted for. Now, I don't know if you've really thought about this, but if you purchase a house that has, say, I don't know, a ceiling, or let's be more direct, a ceiling that doesn't have flood damage on or flood stains, and then during one of your buyer visits, you look up and there's suddenly a flood stain. Well, you're not receiving what you've contracted for, which is really a basic concept in contract law. There's an implied term of contracts, many of them actually, but one of the implied terms is that a seller cannot convey an asset that is different in quality than what it is that they had originally sold. So if I purchase a car and say I'll pick it up on Tuesday, and I come back on Tuesday and the rims have been changed on the car for lesser rims, or if I purchase a house that has a certain set of chattels, which I stupidly, as part of my agreement of purchase and sale, just wrote stove, but the chattel is different, and they've replaced my Miele stove with, I don't know, a GE stove. Well, I am getting an asset that's different in quality than what is sold, and thus the fundamental implied condition of the contract has been violated, right? And so it is that, because, things happen. These are usually agreements of purchase and sale that take up to 3 months to close, or sometimes even more. And things can happen in 3 months. And if something happens that massively affects the property or even minorly affects the property? Well, those are defects that we can claim, even if you have nothing else in the agreement, that claim that fundamentally we are not receiving what it is we have contracted for. And that matters. Okay, let's talk about some other remedies or some other concepts in law that would allow a lawyer to write a letter to the other side, pretty much saying, hey, we have a problem here. We have an actionable wrong, which if taken to court, the court would agree with, thus giving rise to any number of rescissions and damages, which again, we will speak about shortly. Let's talk about a big one. Let's talk about patent and latent defect. Now, this is different than concealment, but only slightly so. In fact, this is probably what concealment is through case law. So, there is an expectation that there is no expectation that something that is visibly apparent as a defect be actively revealed by a seller. What do I mean by that? Well, if you walk in to a house and see a giant crack on a wall, like, you know, like one of those cracks that show that a house is shifting or something, just down a wall, there is no obligation that a seller has to call your attention to that crack. That crack is a patent defect. It is visibly obvious on its face, and any reasonable person with their eyes open would see it. You have no more obligation to call people's attention to that than someone who's selling a used car with rust all over it has to call the attention to the buyer that, hey, this is a rusty car. It's obvious. Sure, someone may miss the rust, but if they miss the rust and it's just bloody obvious and it's all over the roof, I'm sorry, you got to use your eyes. Like, at some point, the law isn't there to protect you. You have to ultimately be responsible for patent defects. But that's different than a latent defect. Latent defects are those defects that are not discoverable through the exercise of reasonable diligence. Now, that's different than concealment, by the way, and I'm going to point out what the difference is. You may know of a defect, but that defect hasn't been actively concealed by you, right? You may know that the house is shifting, but you haven't done anything to stop the buyer from seeing that. So that's the minute distinction between concealment and latent defect. But your knowledge as a seller that the house is shifting is a relevant factor that may not be discovered on closing or prior to closing. And if that's the case, you should know that you have trouble or you are in trouble as a seller. Because as a seller, the law on latent defects is that they must be disclosed by the seller. If you know of a latent defect and you fail to disclose, then that is grounds for the buyer to come back before or after the contract, talk about after, and say that you knew of this latent defect, you knew that I was unaware of this latent defect, and you did not disclose this latent defect. And there's ample case law to show that a latent defect is a mechanism of getting around caveat emptor. Yes, it's the buyer beware, but if the seller has knowledge that things are not as they appear and the buyer has no reasonable chance of actually discovering that themselves, the law does put some obligation on people to fundamentally address that inequity.
Mark,
Yes.
what can you define reasonable diligence on the buyer's end?
I can't define the exact reasonable diligence, but I would tell you the mechanism the court would use to determine it. The court would say, did you adopt a reasonable standard? So the reasonable man standard, it used to be called the reasonable man, it's now called the reasonable person standard. It shows you when I graduated law school. My God. The reasonable person standard is that someone would have acted with equal diligence to what the normal person would have done. So if, for instance, the latent cases that I've seen been successful are people who have made discovery of the property a priority through invoking a home inspector, by going ahead and asking diligent questions, by having email records saying, is there anything else I should know about this property? And at that point, really you're doing what an average interested purchaser should do. So if the nature of the defect is clearly something that is not discovered or discoverable through what normal people employ when they buy a house, and if you can show, and this is the critical component, that the seller had knowledge of that latent defect, and sometimes you can, there's actually very interesting cases that I've seen where you can, then you have a decent kick at the can of going to court on this. Does that answer your question, Jack? I understand it's a bit of a cop-out answer, but
can I bring out for example, two scenarios, and you tell me how would that go down?
Yep.
Let's say there's a hole in the drywall, and it's covered by a large painting, not even, let's say, a heavy mirror. It's a painting that you can lift off easily off the wall to see what's behind the wall. Or let's say in the living room, in the center of the living room, there are some deep scratches in hardwood flooring, and that area is covered with an area rug, and possibly
this is interesting.
small coffee table on it. And so basically, is that a latent defect or not? Were buyers supposed to look, which nobody obviously does.
No. Those are good questions. And the reason that I told you that latent defect is very closely affected with concealment is specifically because if you're trying to prove that if the biggest burden of proof that you have in these instances is showing that the seller knew, active concealment of defect clearly shows that they knew. And in fact, the case law has been that where people have done things like that and concealed, the courts give more deference to the idea that it is a latent defect. After all, buying a house is not a game of hide and seek. You aren't expected to go ahead and try to take off people's pictures and lift up carpets. That isn't what a reasonable person does when they buy a house. What's more, if you can prove that these things were placed with the express intent of defeating a patent defect visible search, a court would be much more amenable to a latent defect argument. And so I think, particularly because the examples that you're providing are combining latent defect with concealment, a court would probably be more willing to find on behalf of a buyer who is claiming latent defect in that instance. Does that answer your question?
Perfect. Now, in reality, it's fair to say that most people wouldn't end up in court, right, over scratches in floor or a hole in the drywall. So let's say you are presented as a lawyer on one side, either buyer or a seller side, with this issue prior to closing. Let's say people have moved their stuff out, and now they notice this damage. They notice the hole in the wall that they didn't see before due to the painting. They notice scratches in the floor that they didn't see before due to the rug. How would you and the other lawyer deal with it at closing?
This is an excellent question, Jack. This is an excellent question, because what you're asking, if I may paraphrase.
Thank you, I try.
What you're asking is, look, it's all well and good, Mr. Lawyer, that you're telling me about the law, but I live in the real world where $1,500 does not stop a $1 million property from transacting. So you can get your head out of your ass, sir, and please start telling me practically, what the heck do you do when you know the law and you can write the nicest of letters, but who the hell cares because it's the day of closing and you're not going to go and invoke the help of the courts? What do you do? That's what you're asking, right? I'm assuming that's what you're asking? Okay, I'm going to assume that's what you're asking.
Yes, sorry, yes.
So the answer is actually very simple. What you do is you write a nice, eloquent letter. You say, look, we're holding you for damages. I want my holdback. I want my abatement. I want whatever it is. And then the other lawyer basically either says yes or no. If they say yes, no problem. You're good. You've done your job as a lawyer. If they say no, then what you do, they say no, and we're going to close. And if you refuse to close, we're going to tender on you. At that point, you call your client and you say this. You say, hey, Johnny, my client's name is going to be Johnny today. Hey, Johnny, so here's the issue. I understand you're pissed off. I understand that you're going to be out $1,500 and you're going to have to repair this. I got it. We as lawyers do not think, well, first of all, on a business side, it makes no sense to torpedo this transaction, so we're going to proceed. Unless you tell me otherwise, we're going to proceed. But there's no reason you need to take it. And what we are going to do is our job as lawyers is going to be to start putting you in a position where, after closing, you can sue. Because if you recall what an agreement of purchase and sale is, after you finish closing an agreement of purchase and sale, you cannot sue the seller except in certain instances. What lawyers do where there are minor amounts still outstanding and they haven't been able to come to a conclusion, even if one side feels that they're absolutely right in law, but the other side is just not cooperating and you don't want to use the courts, is you write the following letter. Dear sir, or dear madam, depending on who the latter lawyer is, we have set out our position at law. Our position is as follows. We are correct. Nonetheless, in an effort to mitigate our damages, we are going to close this under protest. That is the way you write it, under protest. Enclosed, please find our copy of our documents and the monies have now hit your account. And then invariably it closes. And because you have that letter out on behalf of your client can then engage in a small claims lawsuit using the courts in order to seek their justice for the $1,000, $2,000, or even $10,000 that may be experienced in damages. And so really the job of the lawyer, when they discover damages and when the other side is not amenable to close, is to negotiate with the other side if they want to go to court before closing, gumming up the whole works and not getting their house, or preserve their right to sue after closing, which quite frankly, if the damages are less than $10,000, usually makes sense. Now, there's a risk that the seller flees or that the seller has no assets and that they never see that $10,000, and that risk has to be explained to the client. But so long as the client is aware of the fact that they have the right to sue, so long as the lawyer is doing their job and quantifying the risks, then the transaction should conclude on its terms. Does that make sense, Jack? Did I answer your question?
Absolutely. Thank you very much. Perfect.
Okay. Anybody else have any questions to this point before I move on? Nope. Okay, we're good. Okay, so we've talked about ways you can get around caveat emptor, common law. Sorry, did someone else have a question? No, okay. So we've talked about ways that people can get around common law, caveat emptor using common law. But there's also ways that you can torpedo a deal in the event that certain things happen by virtue of what's contained in the agreement of purchase and sale itself. So the first thing I'm going to mention is, you know those standard forms of the agreement that almost none of you really ever read on a per deal basis because you turn to your clients and you say, oh, that's just standard form, let's move on. You know exactly what I'm talking about, every single one of you. Well, if you actually read, and particularly you read the sections you particularly hate, the title section, you'll see that it says something interesting. It says that if the buyer cannot obtain fire insurance due to a previous defect, such as flooding or fire, the buyer may be able to terminate the agreement. Now, fire insurance, it's interesting. I just want to stop and comment about this for 1 second. Fire insurance used to be a separate thing. There used to be separate riders for fire insurance, you name it. But the courts, in a particular decision, I was actually just speaking to an insurance lawyer about this yesterday regarding a different case. The courts have really determined that fire insurance is just generalized insurance. And so while our OREA forms continue to reflect something that says be insured as against fire, the principal building may be insured against risk of fire, what that means in the real world is that the principal building may continue to be insured, period. Because if you get any sort of insurance, then it can be insured against fire. But if something is not insurable against fire, you can't get insurance. So what this is actually saying in English is if you can't obtain insurance, this falls through. Now, some of you are going to say, well, Mark, I've been a realtor for 25 years. I've never seen an instance where something can't get insurance. And to that I say, welcome to the world of climate change. Because it is the case that this year, actually only as of January, that insurers are now massively revisiting risk in light of climate change models. And this is mainly affecting BC, to be sure. It has not come to Ontario in a big way yet. But whole condos are now being denied insurance. Condos are folding in BC because there is no one to give insurance and the government hasn't come to the rescue. What's more, if in fact you are in an area of rising seawater or lake water or anything else, or if there is permafrost issues northern Ontario that are causing fundamental instability of the ground, that is causing structural defect, all of these things are things that our climate models are now predicting, and insurers who do not deny climate change are particularly accepting and incorporating into our fees and their coverage. And as a result, what may have seemed an innocuous sort of clause is going to take on heightened relevance in coming years. Now, granted, we all live in Toronto, not all of us, but most of us live in the GTA, and this probably will continue not to affect us because the GTA alone in this world is like one of the areas that possibly may even benefit from climate change, and isn't expected to have the same impact as other areas. But still, you need to be aware that this is absolutely a clause that gets you out of your deal and may very well be relevant. But let's move on. I digress. One of the other things you can do, and that we have seen regularly, is if in fact there is a problem that has caused substantial damage to the property. So you'll recall when I was talking about the common law remedies, I was saying to you that you have the right to receive what you've contracted for. And what that would mean if there was no OREA form is that you have the right to walk away from an agreement if you like. But the OREA gives the buyer other remedies. It says that you can either walk away, or better yet, you can elect to take the insurance proceeds from the actual seller and rebuild. And so there was, actually, my friend had a purchase on Rogers Road. No, it wasn't Rogers Road. It was, I forget what the name of the road was, but it was by U of T. And 3 old townhomes went up, and his client had a right to purchase, and they completely burned them to the ground. And at that time, the purchaser was bereft until someone pointed out Section 14. And at that point, I mean, I guess it wasn't exactly consecutive, but had someone pointed out Section 14, the guy would have been sitting there with popcorn watching it burn. Why? Because what he was getting was a brand new townhome. What was happening was there was substantial damage, and the seller was obliged to take the insurance policy that they had on the premise and assign it, if so needed, to the buyer such that they could rebuild a brand new house. And so the buyer, for the cost of a resale home, got a brand new home. And so I'm pointing that out. The buyer is allowed to terminate, but equally they're allowed to take the insurance proceeds, which is usually what they do. Or the seller goes ahead and uses the insurance proceeds before closing to fix it up to the same degree, which you cannot do if the house is fully burned down, but you can do in the event of, say, a basement flood or anything else. Okay. Another way of getting around caveat emptor, which we're seeing take place more and more, is the overarching principle of good faith. If someone acts in bad faith, and I know we've talked about Basman and Harnu quite a bit, and actually there's a whole series of case law as to how this is now being interpreted across the board, and I don't intend to get into great detail about this right now, but suffice it to say that if someone uses the contract in a way that is just, they act with bad faith, well, at that point, you can get away from the contract as well. I actually think I'm not going to actually turn my attention to this too much, just to keep things clean today. There's any number, I think I'm going to give a whole lecture on good faith and what that means and how the courts have interpreted it in the coming weeks. So I'm going to save that if you don't mind. All right. So what we've done now is we've established that there are, we've only talked really about prior to closing, but we've said that there's defects. The seller has said caveat emptor, and we've gone to court and we've said, no, It is caveat emptor that is the law, but you actively concealed, say, a latent defect. You innocently, negligently, or fraudulently misrepresented. I have the right to receive what I've contracted for, and this property is different. There is either a giant problem with obtaining insurance, or there has been a massive fire at the premise, burning it down, and I want to terminate. In all instances, or you didn't act in good faith. In all instances, I have an actionable wrong, and I can apply to the court. And when I apply to the court, I am allowed to ask the court for remedies. Not every remedy is just a dollar figure. The court has other abilities. First, it can require the seller to remedy the problem before closing. There can be almost injunctive relief, basically saying, you seller must do X. They can do that. They can force specific performance, that is to say, seller, you're to sell this property, but at a lesser price. So we agree that there's $100,000 worth of defect that has been caused by the seller. That has happened actually in the case that I've seen, where seller's wife destroyed some of the property. Okay, well, we're still going to order the sale because that's what the buyer wants, but with $100,000 price reduction, which the seller wasn't willing to give, but the court gave. And that's all there is to it. Done, because you're entitled to what it is you're purchasing. The court can order a holdback. Same thing that people negotiate every single day as between buyer and seller. The court can terminate a contract or rescind it. There could be a negotiated settlement between the parties. Or alternative, I don't know why it says sue seller, and that's kind of what you're doing when you're going to court. I'm sorry, I might have been slightly drunk last night. Or perhaps there's a claim as against title insurance, which we've talked about in some detail actually just last week for those of you who are interested. So you can go to court and you can do any of this. What happens if this damage is discovered after closing? So post-closing, we have risk, and the risk is now passed to the buyer. But that doesn't mean that the seller is fully off the hook. Why? Well, first off, it's partially because of what you do. There are certain clauses where you include the phrase, the parties agree that whatever it is that we've just talked about shall survive and not merge on completion and apply only to the state of property of this transaction. Well, what that means is, if it doesn't merge, the agreement itself, or at least that clause itself, is not an end. It means that the purchaser can go ahead and sue the seller, even after closing, for damages that are discovered post-closing. So most notably, you are aware of this for chattels and fixtures. But there are other clauses available on web forms, by the way, which pertain to electrical, mechanical, plumbing, anything. You can make anything survive closing. And if you stipulate that in your agreement, well, a valid lawsuit exists. Then, of course, the argument that we made before closing, that about patent and latent defects, continues to exist after closing. The seller is capable of saying, I discovered a $20,000 defect, which was latent and in perhaps Jack's case concealed, and it was only discovered after closing. But because it was a latent defect not disclosed that causes me damage, I am permitted to sue you even though the agreement has been at an end. Now, the big problem, of course, is that the seller has taken the money and may have absconded off to Europe or God knows where. And sure, you're just going to have to settle for a judgment and you may not get it back, but that doesn't mean that legally you don't have a right to sue. What happens if the defect is not discovered but should have been discovered by various professionals? Because at the end of the day, it's way better to sue a realtor than it is a seller. A realtor has that beautiful thing called insurance. So oftentimes, people who discover defects post-closing try to sue the professionals because, again, seller may abscond. So the first thing I would tell you is that agents have to do their job properly. And brokers that are acting for listing agents have a duty to make reasonable inquiries about a seller's disclosure. Some of you will have heard of the Settlers Property Information Statement, the SPIS, which no one in the GTA uses because it's been hammered into your house head that there's liability. And that liability really stems from cases like this, where Krawchuk and Sherbak, where a court concluded that an agent basically just accepted it as SPIS, but if they had read through it, it was contradictory on its face. I think at one point of this case, it said that there was no lead piping, and another point it said that there was or something. And, you know, the agent didn't read what was supplied by way of the SPIS. And accordingly, the court said, no, you have a duty to make reasonable inquiries. And by the way, the lawyers have same duty. Like, you know that section 116 where we have to determine residency? Well, it's not just enough to take someone's word for it. If you suspect that that they're lying to you. The lawyers have a duty to also discover whether or not the clients are telling the truth, as much as realtors have an obligation to discover whether or not the accuracy of the representations of their client are accurate. And then, of course, the big question that I'm always given, which is, well, Mark, we had a home inspector, and the home inspector didn't find this. Can we sue our home inspector? Home inspectors, all right, let me be charitable. Home inspectors are good things. They help they help make an agent competent by saying, let's get a home inspector, because this isn't my area of expertise. Let's defer to someone who is an expert. So from your perspective, and saving your ass is good. From the perspective of a home inspector, there isn't much liability that they take on. If any of you have seen a home inspector report, they fully absolve themselves of pretty much everything. What's more, outside of really figuring out what roof dates are or some minor issues, they certainly can't help you with latent defects or major problems. And until really recently, the 2000s really, home inspectors were never liable for their work. Similar to mortgage brokers who have professionalized significantly over the past 25 years, home inspectors are starting to professionalize. Many of them have insurance. By the way, not all of them have insurance. I think they're passing an act. They may have passed. They may now all have insurance, but they didn't have insurance for many years. There are standards that are being established in the industry. And what's more, courts are starting to hold them accountable for gross, obvious defects. The most obvious case was Brown, John, and Ramsey, I believe, where there was just visible termite damage that was missed by an inspector, which is, under any inspector, a reasonable standard would be to basically be able to see that because it was just obvious on its face. But there were other cases, such as this BC judgment, where a home inspector missed a patently obvious defect. And this other one, Baker Street home inspections, where I believe it says attic hatch had paint around it, and inspecting the attic would force the paint to be ruined. In that instance, if I recall correctly, there was a structural defect, and they had to get under the house in some way. I forget what that one is. I have to look up that case. I'm sorry. But basically, you have to establish three things. You have to establish that the home inspector misses a very visibly obvious defect, that a normal home inspector would have caught it, and that the inspection to discover the defect would not have caused damage to the property, which the home inspector is not allowed to do. If you can do that, it seems to be that is the burgeoning case law that suggests that a home inspector may be liable. Of course, all of this was irrelevant until they had insurance, but as home inspectors are now starting to be insured, you can bet that there will be more liability that now attracts to home inspectors as well for defects, and perhaps there can be viable sources of lawsuits against them as defects are discovered post-closing. Of course, you also have the right to go against title insurance in certain limited respects, and we talked about that last week with Alex Melfi. Any of you who haven't seen that, I do suggest you watch. So I know this was a bit shorter than most of our times. We're at we're approaching 10:50 here, but that opens it up for questions. If anyone has any questions, I'm interested in taking them. I'm interested in answering, and hopefully this gave you some context as to how it is a lawyer deals with defects, what we do, and how we make our claims. It's open. Any questions, please hit me up. Well, I see that we have, what if you, so Tara wrote, sorry, so Tara wrote me something privately, but it doesn't seem like it's a private question. So with your permission, I'm just going to read this, Tara. What if you find these defects, these types of defects once you receive your keys, and it's the first time you walked in, but the transaction is officially closed? Can you still be in a position to sue? So in fairness to Tara, she asked me this question several minutes ago, at 10:30 actually, and as a result, I have answered that question since. But of course, patent-laden defects, patent-laden defects, as I was talking about, do survive closing and do allow you to sue actively. So yes, you are in that position to sue. Any other questions?
Mark, could you possibly explain to the participants the Harkness v. Cooney reason?
Yeah, well, the Harkness v. Cooney, Sandra, I think I'm going to actually do a whole presentation on it because there's a lot of surrounding case law now that has defined Harkness and Cooney. But in a general sense, what happens if someone is making, say, a representation or a warranty in the agreement of purchase and sale? And so this is an example that I've seen. And that representation and warranty is worded in such a way such that it deflects from people exploring further and covers up a defect. So if someone represents and warrants that says that there shall be no that there are no defects, that there have been no provincial offenses levied against the property, right? And instead, it wasn't a provincial offense, it was, say, a municipal offense. But through the course of conversation, they said, oh yeah, we'll just write, you tried to say, no, that there shall not be any governmental restrictions. And they say, sure, I'll write the paragraph for you. And then they write it as provincial offense as opposed to municipal offense. Well, they're acting in bad faith, right? And as a result, they're doing this specifically to ensure that, you know, they can get away with using the contract in a manner which they're saying to you, hey, I'm ready to work with you. I'm going to just draft it this way. Here we go. And you're thinking that the drafting is covering what it is you've agreed to between the parties. But in fact, it's being drafted in such a way so as to give exculpatory outs to the person who's drafting. That would be using a contract in bad faith. And I know that that's a bit complex, but that would be one example. I will go into some detail in a future presentation very shortly about Harkness and Cooney, because I think that there's enough case law on it to draft it into a fairly substantive discussion point, which I think will be quite interesting for the group. Does that answer your question?
Yes, thank you. I just wanted agents to understand that even if they have written into the APS, you have 2 buyer visits. They are still allowed by law one extra.
I'm sorry, you're correct. Sandra, thank you for not correcting me because I gave you a garbage answer because I was talking about Bassin and Harnu. I'm sorry. Harkness.
Exactly. I figured that out.
That was very polite of you not to correct me, Sandra.
That's okay.
Right. I'm sorry. Harkness and Cooney, guys, is a different case entirely. Please disregard what I just said there. Actually, Sandra, why don't you go ahead? You were properly describing it. Please go ahead and do that. God, I'm embarrassed.
Don't worry about it. You can't have everything all lined up in the brain at once. Harkness v. Cooney, when you do an agreement of purchase and sale for a buyer, and you put in 2 buyer visits, and the 2 buyer visits, you take, grandma and grandpa and the whole family through in the first one, then you take, the drapery people through in the second one. You are allowed in law 1 more visit right before closing, comma, if that has been put into the requisition letter by your lawyer to the seller's lawyer, which it always is, it's a standard clause, comma. But this isn't another visit to drag the whole family through. This is for you to walk through quickly and to look at the property, and all you're doing is you are ensuring that you are getting what you bought. In other words, they haven't changed out the appliances. They haven't changed the paint on the walls. They haven't changed anything from the date of date of negotiating and signing the agreement until getting the keys. And that visit is always given, but agents don't understand that.
That's very true. And generally where that becomes relevant in the court process or in the closing process is where you have antagonism as between the parties, the buyer and seller, and the visits have been used up, and there has been repairs to be affected by the property. If in fact someone then puts up a defense and says, I'm not letting you in until after purchase, and you as the buyer's lawyer are basically saying, well, I don't know if you've finished this or not, I don't know what you've done, I don't trust you at all, then you can rely on Harkness and Cooney, which is a case that dates back, I believe, to the 70s or 80s, which is still the law today, which again, as Sandra eloquently stated, allows you access to the property for the purposes of inspection, the same type of inspection you would get if you were buying a used car. Before you buy it, you have the right to kind of walk around and make sure that the rims haven't been replaced and everything else. So you have a legal right to actually enter into a property regardless of whether or not inspections are contained in your Schedule A or whether you have used them up. So thank you for that, Sandra. And again, apologies for confusing Bassin and Harkness, which is not the measure of a competent lawyer talking about the standard of law. Any other questions?
Yes, Mark, because you guys brought up appliances a couple of times. So let's say the sellers actually switch out the appliances and the buyer's agent did not put in the make, model, serial number in the agreement of purchase and sale. Let's say the buyer's agent just said stainless steel stove, stainless steel fridge, and so on. And they switch out the appliances of lower quality. Let's say they had Miele appliances and they switched them out for, I don't know, Whirlpool. What happens then?
So your question is your question is really the fact that you've mentioned only stainless steel appliance, does that allow them to do this? Because they're replacing it not with a white fridge, but a stainless steel fridge, and thus they are living up to the agreement. And the answer is no, because of the implied term of contract, which you have the right to get what it is you are contemplating. Now, the fact that an agreement was improperly or imprecisely drafted to say stainless steel fridge, it was, in fact, referring to a very particular stainless steel fridge, and no court would interpret it any other way. It does not give allowance to someone to remove the premise, to remove it or switch out the chattels, and it's for that reason that all lawyers recommend that as you're going through your visit of the property before bringing an offer, that you take out your iPhone or your Android and record what the appliances are, such that if they are switched, you have a record of them and can prove to the court that there was, in fact, something different than what it is you had contracted for. Of course, Jack, getting back to your previous question, if they refuse to allow you, or if they refuse to put it back, then because this is for only a couple of $1,000s worth of damage, you would preserve your rights and sue them in small claims court for the difference.
Thank you.
Anything else, guys?
Yes. What is the statute, Terry, date of limitation for making and filing a claim?
So the statute of limitations generally in law is always 2 years from the discovery of breach. Okay, so for most things in a property, that would be 2 years from the time you take possession of the property and then discover that there's a defect. But if the defect itself only becomes visibly apparent, say a year or two after you close, let's say it's a structural defect, and suddenly you discover, and it's a structural defect that results from, say, renovation that the previous sellers had done without permits. Well, when you discover that in year 3, you would think, well, oh God, oh no, my time is up. Your time isn't up. You have 2 years from the discovery of breach up to a maximum of 15 years pursuant to the Limitations Act passed in 2002. Does that answer your question?
It does. Now, if you purchase an assigned property, does that restrict your claim at all?
Sorry, can you, if you purchase a what property, you cut out there?
So buyer is unable to close. They assign the property to yourself. Would you are you able to go after the sellers?
Yeah, assignment does nothing other than put you into the position that the normal buyer would have been in. And the normal buyer has those rights, therefore you take on those rights.
And if you remedy the problem before the claim, does that impact your claims?
No, it doesn't. You have an obligation to mitigate your damage. Mitigation of damage, particularly with bad problems, usually results from, you are not expected to sit and wait for the court process to go forward before fundamentally you resolve a defect. You are perfectly permitted to resolve the defect, keep the invoices, and sue for those damages. Done.
Okay, excellent. Thank you so much.
No problem. Sorry, who was that? Oh, Horace was asking. Okay, very good. What other questions, guys?
If I can add on to that point, one of the exclusions as far as statute of limitations, not really in law, is appliances. If you get in there, you don't have 2 years to say the oven isn't working. In case law, the judges have if the owner says it was working on date of closing and you don't move in for 6 weeks and then all of a sudden turn the oven on and it's not working, a lot of the judges will not grant you damages on that. So I recommend that any agents that are acting for buyers, tell your people to go in, turn the furnace on, turn the AC on, turn the stove on, make sure the fridge is working as soon as possible, so at least they can win in court.
That's true. And I would also mention that there's also, that is combined with a reasonability standard. So if you're taking on a property that's in the middle of January, it's not reasonable to go ahead and turn on your pool. But it is reasonable the moment that the pool is discovered to be defective for you to go ahead and address it and start your lawsuit in June. And no court would fault you for not having done it in January, but people would fault you for perhaps not turning on your oven at the time that you've taken possession. You have an evidentiary burden of showing that the defect took place from the time someone owned the property. And if it's 4 or 5 months after closing and you make your first letter, well, it's very easy as a defense for the seller to say it wasn't broken when I gave it to you. And the court would probably defer to that judgment. Someone has, okay, so we have a couple of other questions here in the chat and we have a couple of minutes, so I'll just finish these up. What about property stigmas? So a stigma would be something like someone has died in a property, property is haunted. I honestly, I mean, look, to my mind, disclosure never really hurts, and most people genuinely don't care when they see their shiny new object, which is their house where they can raise their kids. To the extent that those people care, if they care enough that they would sue you for it, well, it's probably better to disclose it in any event. So usually, if it's something significant like a death, sure, you can disclose it. It's probably not going to affect it very much. I mean, sometimes it does. I mentioned this last time. I once sold a murder house where someone was dismembered in the basement and it hit the Toronto Star. And, we put the Toronto Star article up on the MLS and advertised it as a murder house. And still sold for $250,000 over list. But that was sold to developers so that they can destroy the house and redevelop. But still, disclosure of stigmas, I don't really think it really hurts all that much to do. I just don't think it affects things very much in the GTA market, so why not do it? As to what the law is on it, honestly, I'm a bit unclear. There isn't really a concrete body of case law. It is the case that you have to disclose certain stigmas, like murder and dismemberment. Paul Bernardo's house would have to be disclosed, I would think. But where the line is kind of indefinite, and as a result, I'm going to shy away from answering that other than to tell you, really ask yourself, what's the harm in disclosing? What's the statutory date for limitations for making a filing claim? Horace, we talked about that. Heather now writes, client purchased a loft, tenant occupied, closed in the winter, and condo was turned on, air conditioning, AC is not working. I would suggest to you that AC is one of those things similar to a pool that you can probably get away with if you go to court and say, I only turn this on in the spring. I've seen that happen. I've seen that happen with some success, partly because sometimes the compressors are covered for the winter. Other times it's hard to turn these things on if it's a certain temperature outside, whatever it may be. I have seen claims succeed as against sellers for air conditioning that is discovered 3 or 4 months because the transaction took place in January. So there it is. And yes, they have grounds to move forward legally. Stuart says this was a great session. Thank you very much. I have to run. And even though I read that before, I read it out loud and I knew that that wasn't a question, I felt like patting myself on the back. So there we go. And Sandy says exactly. So I think that we are done today. Guys, I want to thank everyone. We are over 2,000 members in this group. Awesome, awesome, awesome sauce. I will, as always, post a copy of this video on our forum shortly. Thank you, everyone, for attending. If anyone has any questions, please feel free to ask me anytime. Take care. Have a good day.
Thank you very much for a great session.
Awesome.